The single, most expensive mistake in automobile history wasn't a recall or a design flaw, but a moment in 1962 that led to a lawsuit costing over $100,000 in early 1970s dollars, a sum equivalent to nearly $700,000 today. It all started with a tragic car accident in New York involving a Chevrolet Corvair, a car already facing scrutiny for its handling. Arlene Green was driving, and her young son, Paul, was in the passenger seat. They were on their way to visit family, a routine trip that suddenly turned catastrophic. The car veered off the road, striking a utility pole with tremendous force. While Arlene sustained serious injuries, Paul was ejected from the vehicle and tragically killed. This wasn't just a devastating personal loss. It was the spark for a legal battle that would reshape American driving forever, forcing a critical question about who was responsible when a car crash turned fatal. In the aftermath, Paul's father, Dr. William Green, sued General Motors. Now, usually, in cases like this, the focus would be on proving the driver's negligence or a defect causing the accident itself. But Dr. Green's legal team, led by attorney Ralph Nader, took a radical, almost unheard-of approach. They didn't argue that the Corvair was inherently unsafe or that its design caused the crash. Instead, they focused on what happened after the initial impact. Their argument was groundbreaking. Even if the accident was the driver's fault or unavoidable, the car itself should have been designed to protect its occupants from the foreseeable consequences of a collision. This concept, known as crashworthiness, was a legal earthquake, challenging decades of auto industry thinking and placing a new burden on manufacturers. But how could they prove a lack of a single safety feature was a direct cause of death? What was this crucial, missing safety feature? It was the seatbelt. In the early 1960s, seatbelts were not standard equipment in many cars and certainly not mandatory for use. They were often an optional add-on, seen as a luxury or an unnecessary expense by many consumers and manufacturers alike. Dr. Green's lawyers argued that if the Corvair had been equipped with a properly designed and installed seatbelt, Paul Green would have remained inside the vehicle and likely survived the crash, or at least avoided fatal injuries. This shifted the focus from the accident's cause to the vehicle's design in mitigating injury. General Motors, of course, countered vehemently. Their defense was simple. The accident was not their fault, and they couldn't be held responsible for what happened when a driver lost control. This clash of legal philosophies set the stage for a truly monumental trial, with billions of dollars and countless lives on the line. General Motors' legal strategy was multifaceted. First, they argued that the responsibility for safety in an accident lay primarily with the driver. If Mrs. Green had maintained control of the vehicle, the tragedy wouldn't have occurred. Second, they contended that providing seatbelts was a matter of consumer choice, not a manufacturer's obligation. At the time, many drivers actively chose not to purchase or use seatbelts, viewing them as restrictive or unnecessary. GM presented evidence that seatbelt installation was an extra cost, and adding them as standard would raise vehicle prices, potentially hurting sales. They also highlighted the technical challenges of designing a one-size-fits-all safety system that would protect every occupant in every conceivable crash scenario. The court faced a dilemma. Should manufacturers be held accountable for injuries that occur after an accident, even if they didn't cause the accident itself? This was the core question that made the case so pivotal. GM's argument also touched on the economic implications. They projected that making seatbelts standard and redesigning vehicles to be more crash-worthy would add hundreds of dollars to the cost of every new car. In 1960s money, an extra $200 for a car could be a significant barrier for many families, effectively making cars less affordable. For context, the average new car price in 1965 was around $3,200. An additional $200 represented over 6% of the vehicle's total cost. This wasn't just about profit margins. It was about market accessibility. They claimed that such mandates could stifle innovation and harm the American auto industry's competitiveness against foreign manufacturers. This economic angle was a powerful tool in their defense, painting the plaintiffs' demands as unreasonable and potentially damaging to the broader economy. But the plaintiffs had a different kind of cost in mind, the cost of human lives. Dr. Green's legal team meticulously built their case on the principle of foreseeable harm. They presented expert testimony demonstrating that ejection from a vehicle was a common cause of death and severe injury in car crashes, even at moderate speeds. They argued that GM, as a sophisticated automobile manufacturer, knew or should have known about this risk and had the technological capability to mitigate it with seatbelts. They highlighted early studies and internal documents showing that seatbelts could significantly reduce the likelihood of ejection and serious injury. Essentially, they posited that GM had a moral and legal obligation to design a product that protected its users from foreseeable dangers, not just prevent the initial incident. This wasn't asking GM to build an indestructible car, but rather a car that offered reasonable protection in a reasonably foreseeable event, a collision. This distinction was crucial for the jury. After weeks of intense testimony and legal wrangling, the jury delivered its verdict in the case of Green versus General Motors Corporation. They found in favor of Dr. William Green, awarding damages for Paul's death. This verdict sent shockwaves through the automotive industry and the legal community. It was a landmark decision that established a new precedent. Manufacturers could be held liable not just for defects that cause an accident, but also for design flaws that fail to protect occupants during an accident. This concept of crashworthiness or second collision liability was now firmly enshrined in American tort law. The immediate financial cost to GM was significant, but the long-term implications were far greater. This single case fundamentally altered the landscape of product liability for automobiles, setting the stage for future safety regulations. But the story didn't end there. An appeal was inevitable, and the industry was not going to give up without a fight. General Motors, as expected, appealed the verdict. While the appeals process saw some legal back and forth, the core principle established in Green versus General Motors Corporation held firm. The case became a cornerstone for future litigation and, more importantly, for legislative action. It provided strong legal backing for advocates pushing for mandatory safety standards. The verdict effectively told automakers, if you don't provide these safety features and someone gets hurt as a foreseeable result, you could be held liable. This wasn't just about seat belts. It opened the door for regulations on airbags, reinforced chassis, and other passive safety systems. The pressure mounted from both the courts and public opinion, fueled by cases like Green's, to make cars safer by design. This brings us to a common myth many people still believe about seatbelt laws. Here's a common myth. Many believe that seatbelt laws were enacted primarily to protect drivers from themselves or to generate revenue through fines. While fines certainly exist and self-preservation is a benefit, the true impetus, particularly in the early stages, was rooted in legal liability and public safety. Cases like Green versus General Motors Corporation demonstrated that the lack of seat belts was not just a personal choice, but a design omission with devastating, legally actionable consequences. Automakers faced massive financial exposure. The federal government, through agencies like the National Highway Traffic Safety Administration, NHTSA, then stepped in to standardize what the courts were demanding. This wasn't about punishing drivers. It was about protecting them and mitigating the financial and social costs of severe injuries and fatalities. The legal system, in essence, pushed the industry towards safer practices, which then led to mandates. Following cases like Green, the legal and regulatory landscape shifted dramatically. In 1968, the National Traffic and Motor Vehicle Safety Act mandated that all new cars sold in the U.S. must be equipped with seat belts. This was a direct response to the legal precedents being set. However, mandating their installation was one thing. Mandating their use by occupants was another. It took decades for states to pass primary seatbelt laws, allowing police to pull over drivers solely for not wearing a seatbelt. New York was the first state to implement such a law in 1984. Today, every state except New Hampshire has a mandatory seatbelt law with varying degrees of enforcement. This evolution from optional accessory to mandated use reflects a societal and legal understanding that seatbelts are a critical, life-saving device, a journey largely started by cases like Green's. But what happens if you don't wear one? What's the real cost if you make the mistake of not wearing a seatbelt today? Beyond the obvious risk to your life and health, there are significant financial and legal repercussions. In most states, a seatbelt violation carries a fine, often ranging from $25 to $100 plus court fees. For example, in California, a first offense is typically $20, but with fees and assessments, it can quickly escalate to over $150. Repeat offenses are even higher, but the biggest cost comes in the event of an accident. If you're injured while unbelted, your personal injury claim could be significantly reduced by the legal principle of comparative negligence. Insurers and courts can argue that your injuries were made worse by your failure to wear a seatbelt, reducing your compensation by 20%, 30%, or even more. This isn't just a minor deduction. It could mean losing tens of thousands of dollars in medical bills and lost wages, all because of one simple, avoidable choice. The legacy of Green versus General Motors Corporation extends far beyond just seatbelts. It fundamentally changed the way we think about product safety and consumer protection in the United States. It paved the way for regulations requiring airbags, anti-lock brakes, and electronic stability control, all designed to protect occupants in a crash. It established the legal framework for holding manufacturers accountable for the safety design of their products, not just their functionality. This case is a powerful reminder that individual tragedies can ignite monumental legal shifts, leading to widespread benefits for public safety. It demonstrated that courts can be a powerful force for change, pushing industries to prioritize human life over profit margins. So, the next time you buckle up, remember the Green family and the legal battle that made a universal safety standard. But what about another pervasive legal issue? The Green versus General Motors Corporation case ultimately taught us that manufacturers have a duty to design products that protect consumers from foreseeable harm, even in situations they didn't directly cause. It was a pivotal moment in American legal history, costing GM significantly and saving countless lives. If you're wondering how individual actions can lead to massive legal ramifications, like when a simple neighborhood dispute escalates into a federal case, you want to watch our next video on how property line disagreements can turn into multi-million-dollar lawsuits. And if you found this deep dive into courtroom history fascinating, please consider subscribing for more true legal stories told simply.